So what we're going to cover here today is international patent protection and some ways to achieve that um, using the Patent Cooperation Treaty. And so I'm going to go through the details of that process, why it's important, some of the key deadlines, benefits, etc. Um, and yeah, and then there'll be a little bit of time left at the end for questions. So just, this is the lawyerese part. Few disclaimers. This is just general legal information. It's not legal advice. So if you want me to give you guidance about your specific situation, just get in touch with me privately. Also, this is an open presentation where there may be multiple attendees. Nothing you say here is confidential or covered by the attorney-client privilege. So don't discuss anything you consider to be confidential. Also, this is going to be recorded, and by joining, you are consenting to my use of your voice and image in any recording, and it'll probably be posted on my website only. So here's our agenda. So we're going to talk first about international patents in general and why they're important. I'll talk about the PCT international patent system, the benefits of that system, procedure, the deadlines and estimated costs, and then I'll go through a glossary of key terms at the end. I may gloss over the glossary, go through it quickly because I'll be using a lot of these terms along the way in my presentation. So, hopefully by the end of the presentation, you'll be familiar with each of the terms I use. So let's talk about international patent protection generally, and step back to a high level, which is why, as an inventor or applicant or business owner, you might apply for patent protection, right? So in the United States, an issued United States patent gives you the exclusive right to make, use, and sell the patented invention for 20 years from the date of filing the application. So basically, this is a government-sanctioned monopoly. And so if somebody comes along and copies your patented invention, you can sue them for patent infringement in federal district court and hopefully get an injunction from them continuing to sell the product and potentially money damages for those sales. And, but the US patent is only gives protection in the United States. So, one of the questions that comes up all the time is if somebody makes something in China and they ship it over to the United States to sell it, is that patent infringement? Yes, the sale of the product in the United States would be considered to be patent infringement. But if that same company turned around and sold the product in China and you don't have, a Chinese patent that covers the same invention, that would not be patent infringement. So, US patent alone does not give you any right to claim infringement outside the United States. So what I tell most inventors who are getting started is if you plan to do business outside the United States, just as you would protect your US revenues with a US patent, you may want to plan to protect your international revenues with a patent in the specific international jurisdictions where you plan to do business. It's not really possible or advisable to get one patent that covers the world or even a huge set of countries. It is a process where you have to go through with each country, and so the cost can get fairly high to seek patent protection in a number of countries. So it's critical that you kind of assess where you may need protection, and plan ahead for that. And one of the tools I would use to decide that is revenue protection projections for any product that you're planning to sell and in what countries. So there is a key deadline here, which is that typically any international patent application that claims priority to US patent application has to be filed within 12 months of the US application filing a priority date. This is true for PCT patent applications, but it's also true if you file directly, say, in Canada or Mexico or the European Union. There's a 12-month deadline to claim priority. So, you know, in some cases with a new product, you have to make a decision before you really know how your sales are or where you're selling the product. But it's a little bit like an insurance policy, and it's something that you'll want to look at as a business owner. So now we'll dive into the patent cooperation treaty. So I mentioned filing a patent application in a foreign jurisdiction, foreign country. There's two ways to go about it. One is to just file an application directly. You hire local counsel in, say, Canada or in the EU, and they take your US patent application and they file it directly in that country. And that can be a perfectly acceptable way of seeking international patent protection, especially if you're sure of where you plan to seek protection and sort of the revenue model for your business. But if you are not sure what your plans are, your business plans are, a PCT patent application can be a really great option to over filing directly in specific countries. So the Patent Cooperation Treaty is a treaty that there's a number of countries that are signatories to it, and it establishes this unified international system for inventors to file a single patent application that then can be used as the basis for applications in multiple countries. So a single PCT application basically has the same legal effect in any of the participating countries as a direct national application. And there are 158 member countries. These are called contracting states that are members of the Patent Cooperation Treaty. And this includes all of the world's largest economies, like the US, the European Union, China, Japan, South Korea, Australia, Mexico, Canada, pretty much anywhere you want to do business. One notable exception is Taiwan is not part of the PCT, but their most developed economies are members of this treaty. And on the other side of the presentation, here's the first page of an international patent application that is published through the Patent Cooperation Treaty. You can just see what it looks like. So the benefits of the PCT are pretty substantial. First is it's just a single application that's filed through your local patent office. And for US inventors, this is going to be the United States Patent and Trademark Office, the USPTO. The process is managed by the World Intellectual Property Office, WIPO. And I think perhaps the biggest benefit of PCT applications is it gives you extra time to decide which countries in which to seek local patent protection. In the term that we use to describe the individual countries where you seek patent protection is we call it the national phase. But the a PCT application gives you 30 to 31 months, depending on the country, from the priority date. And this is the original US application or original priority application priority date to enter the national phase rather than 12 months. So, this can be a fairly substantial amount of time, a year and a half or more, which gives an inventor or a company time to test the market, figure out what their business looks like, which countries they're in, whether it makes sense to file for patent protection in which countries. 18 months does not seem like a long time, but in the world of technology and new products, it's a very long time. And also as part of filing a PCT application, you get a search report. And a search report is a report that one of the search offices puts together that tells you their opinion of patentability for your invention. And so you get this report fairly early in the process, and this can tell you whether it's worthwhile to proceed with national phase applications or what the risks are, what the prior art is that came before your invention that may affect the patentability of your invention. So this is a valuable um, part of the PCT process. So I put together a timeline here of the process for filing a PCT application. So first, of course, is application filing. This occurs 0 to 12 months after the priority application is filed in the local patent office. There doesn't have to be a priority application. You can go directly uh, with a PCT application. But if you do have a priority application, again, the PCT needs to be filed within 12 months of the priority date of the priority application. So the next step that will happen along the process is a formalities check. This is where the local patent office, the receiving office, where you file the application, checks to make sure that your application meets all of the legal requirements for a patent application. Did you sign the right declarations? Are the right uh, fields filled out? Did you give them all of the parts of the application they need, the specification drawings, abstract and claims, etc. So this will typically happen by 1 to 2 months after filing your PCT application. And then the next step in the process is the search office will deliver the search report. And the deadline for this is 16 months after the priority date, but it typically happens within a few months of filing the PCT application. I would say about 4. Um, and, you know, one of the options in the PCT process is you do get to choose your search office, your international searching authority, which is the term that's used in the PCT world, ISA. And so you can choose the USPTO if you like that. The cost is lower with the USPTO. You could choose the European Patent Office. They charge more money, but their results may be more relevant to filing national phase applications in Europe, Japan, South Korea. There are a number of ISAs, and this is something that can be a strategic decision if you need it to be. So uh, again, you get your search report about 16 months after the priority date, or maybe 4 months after filing the application. Publication occurs 18 months after the priority date. This is pretty much all PCT applications are published by WIPO. And there are some exceptions, and you may be able to keep your application from being published under very certain small circumstances. But most applications are published after 18 months. And then 30 to 31 months after the priority date, you have to enter the national phase. This is the deadline to file an application in a local jurisdiction, foreign jurisdiction, um, that that claims priority to your PCT application. And it's very straightforward to just take the PCT application and file the national phase application in the individual countries. Now, one of the important notes here is that most countries are 30 to 31 months. It's good to just keep 30 months in your head. There are a few countries that have 22-month deadlines. They are strange countries. I think Lithuania and Tanzania, not often ones that come up for US clients, but it's just important to be aware. And the other part of this national phase process is that it does require a local attorney in that country to file the application. So, um, you know, you may know this, but attorneys are fairly protective of their business. And so They want to make sure that local counsel has to um, do work in the local jurisdiction, just like a foreign patent attorney cannot file an application in the USPTO. I, as a US licensed attorney and patent attorney, cannot file an application in the European Patent Office or in the Chinese Patent Office, etc. So, also in the national phase, depending on the country in which you seek to enter the national phase, you may have to translate your application. This can be a fairly substantial cost or a substantial percentage of the cost. So, for example, if you want to enter the national phase in China or Japan or South Korea, that application, the PCT application, must be translated into the local language. I guess it's worth mentioning that you can file a PCT application in English, French, or German. But once you reach the national phase, it needs to be in the local language. So, um, because we speak English here in the United States, that's usually the language that I deal with filing PCTs. And that language gets good coverage. For example, an English language application can be filed in the EU. Um, so, a little detail on each of the application or each of the process steps, right? And I've talked about all of this a little bit before, but I'll break it down into a little more detail. So the application filing stage, most PCT applications claim priority to a prior filed patent application that was filed in the USPTO, or at least for US clients that I work with. They typically start the patent process in the USPTO and then continue it with a PCT application as they go through the process. So again, the deadline to file a PCT application claiming priority to a prior application is it has to be filed within 12 months of that priority date. And that's the first priority date. So, there's some date magic that needs to be taken into account. So if there was a provisional patent application and then a non-provisional filed, you really need to look at the date of the provisional application to get the best priority date. And your 12-month clock starts from that date of the provisional. This is where it's really helpful to have an attorney who understands the process, make sure that you meet your deadlines. And it's not required to claim priority to a prior application, but if you have a prior filed application, you've missed the PCT deadline. In many circumstances, that prior filed application can then be cited as prior art to your PCT application. Not all, but in some. So again, this is a place where it's really important to get a licensed patent attorney to really look at your situation. And it's better to avoid the situation where you've missed the 12-month deadline. So the next stage in the process is the formalities check. The receiving office, that is the USPTO usually for US applicants, performs a formality check. This is just the same type of check they perform when you file a US patent application. Did they receive all the forms they need? There is a single form that gets filed with a PCT application that is generated by a tool on the WIPO website that generates all the forms that have to be filled out and signed by the applicant. And then you have to also provide the same elements that you would provide for a US application: an abstract, a detailed description or specification, black and white line drawings, and claims that outline the metes and bounds of the patented invention. So the receiving office then reviews all these documents to make sure that you've provided everything that you're required to provide, and that basically all the T's have been crossed and I's dotted. And if they are not, they will send the attorney a notification saying, oh, you need to make sure you provide this, and there'll be a deadline that's associated with that. typically 2 to 3 months. So the next stage, this is kind of a critical phase of the PCT process, which is the search report. So as I mentioned before, uh, as the applicant is able to choose a specific ISA or international searching authority that generates the search report. This can be a strategic decision based on where you think you might be entering the national phase. Um, there are opinions that certain patent offices do better quality searching. There are also cost uh, issues to be looked at here because, for example, getting a search done by the USPTO is much less expensive sometimes than, say, the EPO. But in certain circumstances, people think that the USPTO doesn't do as great a job. And it may be true, especially if you want to enter the national phase in the EU. You may want the EU Patent Office to perform that search. So popular ISAs are the USPTO, the EPO, Chinese Patent Office, Korean, Japanese, Canadian. I find that a lot of my clients are interested in Canada and Mexico, and the EU and some of the Asian countries, and you can get, a lot of coverage with just, Canada, Mexico, the EU, and China, Japan, Korea. Um, so the search report provides this, initial report, a snapshot on patentability of your invention that can really be useful to decide next steps. Um, it can be the situation where you get a green light, oh, you should move forward. There's not any significant prior art or things look really good. In many cases, there is cited prior art that you have to pay attention to. It may require claim amendments when you enter the national phase, or during the international phase, you may decide you want to amend your claims. Um, and then in some certain circumstances, it can be an absolute red flag that you are not going to uh, get granted a patent for this invention and that you should not invest any more funds in the patent process for this invention. And this search report is typically delivered within about 4 months of filing the PCT, but it is required to be delivered no later than 16 months after the priority date. Publication. We talked about this. This is really simple. PCT applications are published by WIPO, World Intellectual Property Organization, with 18 months after the priority date. This is also true for US patents, by the way. So, there are certain steps that can be taken to avoid publication for particularly sensitive technology. It requires a showing of the right circumstances, and it's something you should discuss with your attorney before you decide you don't want your application to be published or qualify for non-publication. So the national phase. This is when the applicant or inventor picks out the specific foreign jurisdictions where they want to seek protection for the PCT application. The PCT application by itself is not an issued patent, it's just an application. And so you have to enter the national phase in order to actually get an issued patent. And like I mentioned before, there's 158 contracting countries. The deadline is 30 months for many countries, 31 months for some also. And it varies from country to country. So you should probably just keep your eye on the 30-month deadline. There are a number of 22-month countries that are not all that relevant to most clients. And as I mentioned before, the application may need to be translated depending on the office, right? So, as a US attorney, when I file a national phase application in China, it needs to be translated into Chinese. And that can be a fairly sizable percentage of the total cost for entering the national phase in China and Japan specifically. So once you enter the national phase, the application is going to be examined by the local patent office. They're going to review the search report. You do have to have local counsel. And one thing that also is a little bit different in a lot of foreign jurisdictions from the U.S. Patent Office is in the U.S. Patent Office, you file a patent application, you pay the filing fee, the search fee, and the examination fee. The examination happens automatically. There's really no way to stop that application from being examined or to choose when it gets examined. But in a lot of foreign jurisdictions, you actually have to request examination of the application, which doesn't happen automatically. So this is something that local counsel will help you with. Sometimes the deadline for examination is later, which again can save you a little bit of money while you figure out your product strategy. The local patent office is going to be the final decision maker about whether they grant a patent or issue a rejection. And all the same steps are possible in the process of patent examination, where if there's a rejection, your local counsel may present arguments, amend claims, and there's a lot of choices for how to deal with a rejection. But ultimately, that all happens with that local patent office. So in the example of a Chinese patent application, it's a Chinese patent office that does that. All right, deadlines. These are really critical. I've covered all of these in the prior slides, but I just want to mention them again. And the one that I think is most important for inventors, new business owners, anybody who believes they have a patentable invention, is that you have to have 12 months from the priority date of your priority patent application to file a PCT patent application. And I think at this point, it's also good to cover the deadlines for filing a US patent application based on an invention you make in the US. So there is what's called a 1-year on sale bar in the US. So if you have a new invention and you offer it for sale, publish it in a printed publication, publicly disclose it, you have 12 months from that date of the first offer for sale, public disclosure, printing in a printed publication. This includes the internet, of course, to file a patent application. 12 months from the earliest one of those dates. So, if you enter the market with a new product, you've really got to get your patent application on file by 12 months after you enter the market. And then you have another 12 months from the date you file that US patent application to file a PCT patent application. So the search report, it must be received within 16 months of the PCT application party date. Usually happens within a few months of the filing. Publication happens 18 months after the priority date. And then you have you have 30 to 31 months for most countries to enter the national phase. Two shorter deadlines are Luxembourg and Tanzania. So, if you want patent protection in Luxembourg and Tanzania, you should definitely raise your hand early in the process. Okay, this is a question that most people ask, and I saved it to the end because it's maybe not the most popular discussion, but what are the costs, right? And so, as with any business venture, you have to weigh the cost of seeking the protection versus your actual potential revenue and profits, right? This is a decision that every business owner has to make whenever they invest capital to make a new product, to market a new product, whatever it may be. Legal fees are just another category in the launch of a new product, right? And while you certainly don't want your legal fees to be the most substantial portion of your launch budget, you also want to make sure you're not missing any opportunities to protect a valuable product in the countries in which you're selling that product. So the fees vary a great deal based on a number of factors, which can include the number for PCT applications, the number of pages in the application, the number of claims, the choice of International Searching Authority or ISA. Also, there can be different fees for different size entities for the US part of the fees. So, there's micro entity, small entity, and large entity. Most clients I work with who are small or medium-sized companies or inventors just getting started, they're either micro entities or small entities, which can give you a bit of a discount on the filing fees. Um, but in the international phase, the WIPO and USPTO filing fees combined range anywhere from about $2,000 to $4,000. They can be less than $2,000 in certain circumstances for the small micro entity, the minimum application size, but it's not, you should probably budget around two to $4,000. The legal fees then, this is my fee, runs $4,000 to $6,000, and I offer a flat rate for filing a PCT application. So um, if you work with me on filing a PCT application, I'm going to give you a single price to get that application on file plus the filing fees. So you don't have to worry about any additional costs. It's not hourly. Um, and then the national phase, this really varies depending on the country you're looking to seek patent protection in. And so the service and filing fees can run anywhere from $1,000 to $5,000 per jurisdiction. For example, it's fairly inexpensive to file in Canada. You don't have to translate the application. The fees are low. But if you are in the EU, the fees can be fairly substantial. The filing fees are high because you're covering a fairly sizable number of countries. Um, and so, and then if we take the example of China, I would say 50% of the cost of filing a national phase application in China is the translation cost, which can be, so anywhere between 750 to $1,000. And you may say, well, can't the computer just translate the application? Well, it can, but the output is not of substantial quality, especially for technical disclosures, to really be suitable for filing a patent application. I mean, the devil is in the details with patent applications, and you really want to make sure that your application is translated by somebody who's familiar with the right technical terms and localization factors. And so there is a cost to it. Um, so I have this PCT glossary. I'm not gonna talk through each of these things because I covered them all in my prior presentation. I'm just gonna flip through these. If you see one that you want to have a question about, maybe let me know. Um, but these have all been covered in the prior slide, but these will also be in this deck, which I will post as a PDF on my website and send out the link so you can download it at your leisure, have it to refer to, if you have questions in the future. And so these are the terms that are used in discussing PCTs. So if I talk to you about filing a PCT application, I'll define these terms for you, and then I'll start using them when we talk about it. So, questions. Do we have any questions out there?
Got a couple of questions I wrote down
Sure.
as you were going through that. You answered my first one. So this is a very kind of specific question, but sort of points to why somebody would go through this process and get patents in multiple countries. If if I'm a small business owner manufacturing a product that I've patented, and I work with a manufacturer in China, without a patent in China, is there anything to stop my manufacturer from just making double the quantity that I ask for and selling the other half in their market?
There is not technically anything that would prevent a Chinese manufacturer from doing that. And, this leads me to a really important point about working with manufacturers, especially overseas, there really needs to be a relationship of trust with uh, that manufacturer. You should have the appropriate legal documents in place with that manufacturer. Uh, which includes a non-disclosure agreement that includes a very strong non-use clause where they cannot use any of your confidential information for any purpose other than your own projects. Now, for Chinese manufacturers, if you make such a contract, you have to go enforce it in China. But I think it's really important to do it, and it's also important to know that your manufacturers are trustworthy, right? Um, and that's something that as a business owner, it's important to do the research and make sure that you really trust who you're working with and that they're not going to turn around and sell it out from under you. Now, you could seek, file a PCT application and then seek protection in the Chinese market. And then you might have an infringement case if they were selling the product in the Chinese market. But I would hope that that would not happen with a properly vetted manufacturer.
Yeah, me too.
Mhm.
Um, I'm going to kind of jump in a different direction here for my
Okay.
next one. But my understanding is the search results when you go through the USPTO, they're kind of a there's only a couple of designations they'll give you in terms of their findings and their opinions on whether it's worth pursuing. Is it the
Right.
same thing with WIPO?
So it's a different format, the results. And, in the USPTO, when you file an application and you get a rejection, there'll be an office action and they will cite one of two US code sections for a rejection over prior art. One is for anticipation, which means that the prior art that they found has every element of your claimed invention in it, right? So it's not new, it's already existing. And then the other code section is obviousness, which means that in layman's terms, two different prior art references or more are combined and have all the features of your claimed invention. They typically have to be in the same technical art because the legal language is, would it be obvious for one of ordinary skill in the art to combine the inventions, right? So if you're dealing with semiconductors and you have, two different semiconductor patents that then have all the claims, all the elements of the claims of your filed semiconductor application, then you might receive an obviousness rejection. That's under US Code Section 103. So it's 102 and 103 are the code sections for the US patents process. In the search reports that are provided by the ISA, they talk about novelty and inventive step, and they're basically mean the same thing, and so they will categorize prior art references in three categories. Um, whether they prevent you from having something that's novel or new. Novelty, inventive step means obviousness, and then they'll also provide references that they think that are generally instructive to the art that don't necessarily lead to a rejection, but that they think are useful for understanding the technical art. And that
Gotcha.
when they provide that search report, they'll also provide you with their reasoning for why um, each reference fits into what category.
Understood. Yeah, that clarifies that. I'm going to keep jumping around here if that's
Yeah,
okay.
keep asking questions.
So this is kind of another clarification one. If I'm a multinational, for the example's sake, I'll say pharmaceutical company that's developed a new drug that I think is relevant in every market, would you need a local attorney in all 158 of those countries and potentially translators in another half of them in order to protect it globally?
Technically, yes. Um, I don't know that anybody really, I mean, pharmaceutical companies may well do that, but they are looking at products that potentially have billions and billions of dollars of revenue. So it may be worth it for them to spend, $5,000 a jurisdiction to make sure that they're protected. And I'm not a pharma attorney. That's not my expertise. So I'm not 100% sure what they do. But I'm sure that they have strategies around which jurisdictions make sense for them, which ones are not valuable because the patent rights aren't really that enforceable, right? Like you still might have to go to court in that country, and if you can't go to court in a reasonable amount of time and have a reasonable chance of winning, then what's the value of a patent application, an issued patent if you can't enforce it? So these are questions that get asked. I tend to really only focus on the most developed jurisdictions. And the only one where there's kind of a question about that is China. You know, like as a US company, how successful will you be at enforcing your patent rights in China? But I don't know, it's also, do you just want to give up on that altogether at the beginning and not know and not be able to? So those are really the questions that a business owner have to answer, weighing the cost. And that's when I come back to that example of insurance, right? Where, like health insurance or car insurance or life insurance, the person who gets that insurance has to decide whether it's worth um, the protection, not knowing if the event's going to happen. Um, and I guess life insurance, everyone's going to pass, but you just don't know when or how, what's going to happen, right? So um, patents are a bit like that in some regards because you have to decide early in the process if you think it's going to be worth it or not.
Yeah, that's an interesting trade-off balance to
Mhm.
consider. I had one more, maybe even more of a sort of an opinion-based question,
Okay.
but is there a threshold for a number of countries you're considering patent protection in that would make sense to do a PCT app instead of multiple individual ones?
I don't know if there's necessarily a break point of size. But I think that the better analysis would be to look at the certainty of which countries you're going to be in and when, because it can be substantially less expensive just to go direct. Like if you just are interested in Canada and Mexico, it may be simpler just to go ahead and file direct national applications in those countries. But if you're not sure and you want that extra 18 months to decide, that's really
Right,
the value of the PCT, right? Is that
right,
you've got 18 months and you've got this search report and it gives you a lot more information. And in the life cycle of a new business, 18 months can be, you could have launched a product and determined it's incredibly successful, or launched a product and determined that you maybe have to change it, and maybe the patent that you might file might be different, right? Or maybe
right.
it's a bummer and it didn't work out, and you don't want to waste money on filing patent applications against something that the market doesn't really want.
Right. Yeah, that all makes sense.
Yep. We don't like that as patent attorneys, but I will just tell you that there are 13 million plus issued US patents, and there are a ton of those patents that are, were people's dreams and that were never commercialized. So it does happen quite a bit. And, you know, it, I mean, the most important, like, non-legal advice I can give is, just really believe in your product and be, like inventors and business owners are their own best advocates for their products, and they really have to believe in them and sell them. And, the legal process is just part of the overall package of investment for a new product.
Yeah, I hear that.
Yeah. But I don't think any new product, whether it's for an existing successful huge company or a brand new company, can really be successful without a product evangelist, somebody who really believes it, who is out there like behind it, making it work. And Yeah, So they're the person who has to decide ultimately what the strategy is.
Yeah, absolutely. Well, you've covered all my questions here.
Great. Well, thank you for attending, Jack. I appreciate it.